My name is Ellen Lee Zhao, ELLENLEEZHOU. I have been working for our city as a social worker for public health for more than 10 years. I am a SEIU 1021 union delegate for public employees. As you know, we have more than 16,000 members in San Francisco. For many years, many of our public employees have been coming here to report to you about bribery, about harassment, about discrimination, extortion, and retaliation. The people who took the courage came in here and reported to you hundreds. The last time I was here was last month, December 17, 2018. But we do not see a lot of solution from your department or Department of Public Health or Department of Human Resources. I am here today to support my public health colleague, Cheryle Thornton. We work together, we are union representative together. We know as a public employee, we have equal rights, equal protection. From Board of Supervisor, public hearings, and public records, in 2017, our city paid more than $70 million for lawsuits that settled to the public and public employees. Most of the settlement cases could have prevented. We could use the money to build more housings to help the homeless. As you know, in 2017, we have more than 200 homeless people died on the street. And we still have 23,000 drug abusers that depend on our public money to use their drug. Public health supply 400,000 needles free at public dollar to the drug abusers. In another word, our city support drug dealers and dealing it. I challenge you today, if you're not able to do your job as commissioners, maybe think about resigning it and allow other people who wanted to serve our city with dignity to really help prevent corruption, harassment, extortion, discrimination. I am here to pledge to you and ask you to really evaluate our DHR situation. I have, and many people suggest, if the city does not have an evaluation the way that is effective for all employees, we're going to go downhill and more people will suffer, and the city will be having more lawsuits. And I have suggested in here currently, no employee is allowed to evaluate their supervisors and manager. That is a very ineffective government practice.
Your time is done.
Thank you. And here's my public record.
Thank you. I have a question. So, beyond these group of folks standing up, do we have any further folks speaking on this matter? No? We have how many are going to want to come up and do public comment? Okay. Go ahead.
Hi, my name is Cheryle Thornton, and I work for the Department of Public Health. April 1st of 2018, I was removed from my job with no due process. Since then, I've been told that I've been returned back to my work site. However, I was a whistleblower, and there's been no investigation done on my case. So I'm being returned back to a work site where there's been no investigation done. The reason I was told that there was no investigation is because in the city you can only have one remedy at a time, either a grievance or a filing. I filed a grievance, but within the grievance we found discrimination underneath of what was happening. And I spoke to the EEO person in our department about the fact that there's been no investigation. Nobody's being held accountable for the wrongdoing that was done to me. I've been humiliated, I was harmed, and I have not been given an explanation as to why this happened. Racial discrimination and harassment, sexual discrimination and harassment, and wrongful termination lawsuits involve $42.9 million that cost the city every year. And this has happened in the last 10 years under the tenure of the HR Director Micki Callahan. We need this process fixed if under the grievance discrimination is found, it seems to me that labor should stop and EEO should come in to do an investigation and hold the managers and directors and HR or whoever accountable for the wrongdoing, because this is a legal activity. So thank you.
Next speaker, please.
Hello, my name is Daniel Becker. I'm a field rep for SEIU 1021. What's that?
That's good.
This is better?
Well, for you.
Okay. I'm a field rep for SEIU 1021, San Francisco General Hospital Miscellaneous Unit. I'm here to support one of our members, Mr. Nelson Castillo. Nelson was de-skilled in 2009. He was forced out of the city. He then came back and then he was forced to retire. I'm here to support him. Yeah, that's pretty much it.
Yes, my name is Nelson Castillo. I was working for the City Council of San Francisco for 18 years. And the first 8 years, I worked in the medical field and the jail facility, jail number 2 and number 4. Then the last 12 years, I moved to San Francisco General. I worked for wound clinic, wound and bull clinic, as a medical assistant and unit medical clerk. I did my job in very good condition until my manager he was retired. He replaced for a new manager. It was a Filipino race, and she went to the old staff. It was Filipino. Even I working in the right place because San Francisco General, he attended a lot of population, Hispanic population. I'm working with my first language. I help the patient, like interpreter. I order medication. I order everything. The new manager, he started me a restaurant. I went to HR. HR then moved me to another clinic for surgery. My former manager, they recommended to me for another co-worker to do discrimination. And then I coming over here to talk to the civil services tax 2009. They keep going, then they put me crazy. At some moment they forced it to me, HR, to sign it for my retirement. At this point, I need 6 more years to proper retirement. Now, as I coming over here to talk to civil service to get a reinstate, because I'm medical assistant for primary college. I have a bachelor's degree in business administration. I have formerly before 40 years before I coming over here, I went to the medical school for 4 years to the NHA, doctor, veterinary doctor. All of my education is working properly in my field. I help a lot. I need to. I'm part of the discrimination in the general hospital for the Spanish people in African American. And they discovered 3 years ago everything what I say is true, and everybody forced to retire. Now I coming to restate in my position because I'll be out for 7 years. Thank you.
Thank you very much.
I left.
Thank you, Mr. Steward.
Thank you.
Speaker, please.
Good afternoon. My name is Teresa Rutherford. I'm an officer with SEIU 10-1. And again, I'm here to reiterate the fact that our members are not being treated well. Cheryle presented her case, but we also have another member, Ms. Concy Jones, who's also going to present her case. for your review from SFMTA. This is a woman who has worked with the city for 28 years. She has had several recommendations from her boss. She's done everything above and beyond. She's worked on special projects, one of them being SFMTA Net Zero. I mean, she has led this. Her supervisors recommended her, said that she has worked above and beyond her scope. She's way above that. She's strategic. She has the skills. She has the knowledge. Yet she's fighting for a promotion. She is fighting to be heard. She's fighting to be recognized for her body of work. Something is wrong when an African American has worked, done everything, qualified themselves, gone above and beyond, is recognized by their supervisor, is recognized by their department, yet they're being told they do not meet the basic requirement, yet they're being told they cannot be promoted. Let's speak about this. Let's fix this. Let's address this. Because, you know, it's always said that an African American has to be 3 times as good to be recognized, and the city is proving that. So I'm asking you, first of all, in addition to that, my understanding is that DHR has recommended that her case, among several people who approach civil service, they're always told to ignore the case or to dismiss the case. How can people be told that they have a hearing, but at the same time you're being told to dismiss the case even before you hear the case? Something is wrong with that. That is dysfunctional. That's not appropriate. And civil service need to now step back, review these cases seriously, and address them appropriately. We need justice. Justice must be served. We cannot pay lip service to say the city is addressing the African American issue when, under the quiet, employees who more than qualify are still being turned away, are still being told they're not good enough. What else do they need to do? What else do we need to do to be respected and recognized? Part of addressing this racial issue is addressing it and making sure that the workers who have done the job, who merit, who have all the requirements, get where they need to go. You know, none of us come to the city to work for peanuts. All of us have children, families, all of us have hopes, dreams, all of us want to be somebody, be somewhere. So I'm asking you to look at these cases, not to now make a decision arbitrarily to dismiss them, which is what is being recommended, but I'm asking you to dig deep and to look at the justice in this, look at the body of work, and look at the people and realize that you're not promoting them because they're black, you're promoting them because they merit. They've done the job, they deserve, they're qualified, they know what they're doing, and they're an asset to the working force. Thank you.
Thank you. Any other public comment on this item? Hearing, seeing none. Oh, I'm sorry.
Hi, my name is Sandra. I'm one of those ones that have been discriminated against the city and county. I have been one of those ones who've been to the union. I have been one of those ones who said maybe you filled the job application out wrong. And that is very insulting as an African American who grew up here in San Francisco and can't even get a job here since 2012. I think that is an insult. I grew up here. I've seen the changes here. And here I come, put in a job application. Oh, you're not qualified. And then I see, when I go into these offices, as I had a hearing here before, when I go into these offices, I see people who don't even look like me. So it's a problem. And I'm just here to address that, just to let you know I grew up here, and I can't even get a job with the city and county. I'm the one that has the skills. I know how to treat people. And I just wanted to let you know this is dead wrong, you guys. And this feels crazy. Me, African American, standing up here, and I'm talking to you guys, and you guys are not even my own race, but I'm reaching out to somebody who don't even look like me, and you guys act like you guys don't even care. That's all I have.
Any other public comment?
Has workforce demographics across the city and by department on the website. If you look at the website, you can see the banner, and it has says workforce demographics to click on. It's also under classification and compensation. And when you go to that site, you can select. You have to follow the directions carefully, but it's interactive, so you can select a department, or you can select all for all city departments, and then you can look at gender, race, type of employment, for example, permanent civil service or exempt. So that's available, and you can see a 5-year trend. So it's available for each department. We're currently working on putting up some of the larger classifications, in particular, some of those that we heard a lot of concern about, for example, registered nurses. So we're going to be putting that up as well. It's de-identified for the very tiny departments, so that or single person classifications. But for all of the large departments, it's available. So I encourage people to look at that. Secondly, per the mayor's executive directive, we are moving forward with the task force to look at diversity, equity, and inclusion. The first meeting is January 22nd. Cheryle Davis, the Human Rights Commission Executive Director, will be convening the group. And we're convening labor representatives, community organizations, and people who are involved in the GARE project, Government Alliance on Race and Equity. There are many city departments, including our department, have participated for several years. So we're looking for some individuals who are in the second-year cohort to participate and share their experiences. And we'll be problem solving a lot of the issues that came up at the hearings that we've heard about, including recruitment, promotion, retention, discipline, those sorts of issues. So we're looking forward to that happening. Negotiations are starting this month for basically all city contracts with the exception of police and fire. So we have a very big group of negotiators coming in and staff supporting them. Many city employees are involved, but also we have some external chief negotiators because we're not sufficient qualified staff to do it in this very short time frame. We're guided by the mayor's instructions. As you saw from the mayor's budget instructions, her priorities are homelessness, affordable housing, and equity initiatives. The way that translates to us, I think some people may have misunderstood the budget instructions. There is no proposed wage cut and there is no proposed layoff of any city employee. Departments are told to find savings. That is not by reducing anybody's pay. So we're moving forward with that, and I'm sure that we'll be hearing a lot about it as we get into the meat of the matter over the next several months. Thank you.
Okay.
One person in them, so it depends on whether you count those.
We have to budget that $90,000 for necessary cases, especially the recent unexpected one involving her. So there are situations that we need to have a copier, we need to have the printers, and be able to have hire translators or interpreters when our employees need representation. At the same time, supplies, we are doing everything we can to reduce the amount of paperwork. We are trying to advance much more on the technical side when we give our notices of meetings, our agendas, meeting materials. Everything is scanned and emailed out to everyone. So in looking at what the mayor has requested, it's very difficult to look at how we reduce $37,000 without actually having to lay off an employee. Other things that we have talked about is that, and the mayor has asked us to do, is to look at ways that we can run more efficiently and still with the same amount of staffing. And those are things that we are working with. In fact, it's our executive officer who has come out with other plans. Keeping in mind that our department is so much different from the other departments who directly serve the public, whereas as a policy-making body and an appellate body, it's quite different how we service the public indirectly, because it's really our employees that we try to inform and educate. It's our union representatives, it's the public who come ask about our processing, how we go about hiring. We try to be as transparent as possible. And that's how we indirectly serve the public, ensure that our departments are truly hiring the best qualified candidates. And it's based on their knowledge, skills, ability, experience, and education. Did you have any questions for me?
Commissioner Hummel.
So the good news is it's $18,000, I guess. The bad news is $18,000. And so that's half, and then $36,000 is the total, right?
For the 2 years.
So, I mean, You look at the numbers, there's two areas that I would suggest. One is we increase our expenditure recovery by some factor of to be determined, and expand that to, well, let's leave it at that. The second is to work with our colleagues at the city attorney's office and look at that expenditure number and see whether there's a way to get something that reduces closer.
Yes, I'm Jessica Inoue, I'm the field representative, and this is the member, Cheryle.
Right, so you've asked for,
We would like to ask for the matter to be postponed to a future meeting, and not to be heard today. And we also want to request that we be provided with a copy of the staff report, because in order to present our request for appeal, we want to be able to review
Staff
the
report
report.
is online and it is available, but if you want a hard copy, you can also print it from online.
Okay, I don't know, we weren't aware, I wasn't aware that it was available online.
We
Didn't
post
see
our
that.
materials for meetings like 72 hours before the meeting.
Okay.
But however, go ahead with your request.
Well, we have not had the opportunity to review the status report, and so we would request that this item be postponed to the February or March meeting.
thank you, we'll take that into consideration. Does the staff, thank you, does the staff have any objection, or what is your status?
Commissioners, my name is Thomas Duda from the Department of Public Health. We wish to proceed today because the date of this hearing has been known since October 29th, 2018. We are not aware of any additional information that the appellant has provided in support of this request for a delay. And finally, of note, because this matter relates to an examination for Class 2593, that classification is represented by IFPTE Local 21 and not by SEIU 1021. So we are aware of the request for an extension, but we wish to proceed today. Thank you.
Thank you. Colleagues?
Yeah.
Commissioner Halpern?
Is the volume
The appellant is here and has provided public comment today.
Yeah. Can I? We weren't aware, I don't know, I think that,
I'm sorry.
Oh, yeah.
Please state your name.
Jessica Inoue, field representative with SEIU 10 to 1. We did not, I don't think that it's accurate to say that this item has been on the agenda for this meeting since October 29th. I believe the meeting recently, the agenda just was recently made public.
Thank you, colleagues.
that was the staff comments to that last.
The point is well taken. At the time that the Civil Service Commission received the appeal for this matter, the preliminary date of the hearing identified in the receipt letter, which is on page 95 of the staff report, does state that today would be the likely hearing date.
I have one other question to this staff. Are you telling me that SEIU 1021, this is not the union representation, but it's 9593 is IFPTE 2021?
2593, yes, is represented by Local 21. Yes, not 1021.
So this is a union request.
Before I answer that question, I don't know. Let's go to Micki. Micki, you have a...
I would say the person can bring a representative of their choice, and that's the representative, that's your current representative. And it happens to be promotional, so IFPTE Local 21 is the class to which she aspires to promote, but that shouldn't impact the choice of representative in our view.
Okay, thank you for that clarification. Commissioner Fabani.
I was just reviewing a letter from October 29th, 2018, and it indicates that there is the receipt of the appeal and it's forwarding on to the Human Resources Director. It does indicate that the report is due, the Civil Service is telling the Department of Human Resources that the report is due on 26 7th of December and is likely to, so that may be heard on the 7th of January. However, I don't, is the appellant copied on this, or you've got a separate letter indicating the same thing? So that would be on, I just want to clarify to make sure that it's clear to the appellant.
If I can just respond to,
Say it again, I'm sorry.
oh yeah,
Let's-
sure.
Don't see this.
Jessica Inoue from SEIU 10 to 1. We did speak with representatives from the department, the DPH, Human Resources Department, about this matter, and we, and I think our understanding was that the department would provide a response to us of the outcome. I don't believe that we got that response. Perhaps it was only provided to DHR, but I don't know that we were aware of what the department recommendation had ultimately been.
Okay. Thank you. We're having a little discussion here for a moment. All right. Commissioner Petty.
I'm sorry, what page was the letter that, excuse me, what page?
Page 95 of the staff report includes a letter that was provided to the appellant on October 29th, indicating that the likely date of the hearing would be today.
That same letter.
The appellant is not copied on this letter.
I believe that was part of the packet that was provided to the appellant.
So is that letter went to Director Callahan? That letter went to Steward, and I'll carbon copies of that. And then it also went to Cheryle Benson.
On the other hand, my feeling is I'd always want to have somebody with the representation. There's a mix-up somehow or another.
Mr. President, I move we grant the continuance.
I'll second.
Been moved and seconded. Any public comment? Hearing and seeing none. All those in favor of granting a continuance to a date certain? Do we have a date certain?
February, first meeting in February.
February 4th. Okay. That will be February 4th. Is that recorded? And so for the appellant and for the department, will you be ready? Can you take the post and tell us you'll be ready, and definitely tell us you'll be ready?
Yes, Thomas Duda for the Department of Public Health. We will be ready in February, and we look forward to having the commission hear this matter.
Ms. Benton, or the representative, Ms. Benton, please signify by saying, please.
Jessica Inoue with SEIU 10 to 1, and we appreciate and we're prepared to respond to the item in the February meeting.
Okay.
Thank you.
Opposed? The ayes have it. Next item, please.
Hello, Commissioners. Thank you for seeing me today and hearing my appeal. Now, I was at that meeting on September 19th when there were a number of
Could you say your name? I'm sorry.
Demetrius Castillo.
Thank you.
There was a number of African Americans that came and expressed their displeasure of how they were being treated by HR. And evidently, I'm looking at the fact that they recommended to deny my appeal, that, you know, it's business as usual and nothing has changed. I had complained about this 4 times altogether. The first 3 times, the first time I met with Justine Hinderleiter, she, she took my report. And then she went on maternity leave. And so then, they told me they gave it to someone else. And I contacted that person. And I talked to them. And then, about a month later, don't know whatever had happened to them. They, they just do what they usually do, and that's to try and get you to, they try and wait you out and hope you just forget about it. Second time I met with Chris Romero. Same thing happened, nothing came of that. the third time I met with Linda Marini and Laura O'Hare, I believe it was. And nothing ever came to that. So then I said, okay, well, I'm going to go file a formal complaint. So I went in and filed a formal complaint. And as far as I knew, that complaint was, being investigated. Then when I came back to talk to them again, they told me they had no record of any complaint. I said, you don't have a record of complaint. And so they told me nothing had ever been filed. So the guy took my complaint and never filed it. He just threw it in the garbage. And he initially lied to them, saying that he didn't remember anything about it. Then I had him dig up my email correspondence with him, which showed that he told me he was investigating, which was just, it was a complete lie. He was not investigating anything. He just threw my complaint away. And my issue with HR is that how do you hear about something like that and not alarm you? That one of your officers is taking a report that somebody came have you filed and just throw it away. And he kept dancing around that. They never really answered that from what I could see. That was never answered. They kept dancing around that. And, and so and then they gave me the last letter saying they closed it. They figured there wasn't any harassment. And I don't think that they really know what harassment or discrimination is. Because looking at all the issues that they've had and also all these denials, I just don't think that they know what that is. They don't have those sensibilities. Now, I worked for the city for 31 years. I retired at 61. My plan was to go to 62, so I get 2.3 at 62. That's what I wanted to do. But I was under so much stress from how I was being treated that I had to get out here early. My dad died of high blood pressure. He died from that. And I wasn't about to let this job kill me, so I had to leave. Now, I couldn't find in this report my blood pressure health record. Did you see that? I don't know. I couldn't find it in there. And so I tried to send it to be emailed and said, no, you had to have had it brought in, by, I think it was this past Wednesday. I have copies of it now, but my blood pressure was just, it was just out of control. Because I had authority taken from me. I was being questioned about things at my operation, while my counterpart across the bay had all kind of problems, personnel, discharges, operation mishaps. That didn't happen on my side, but I was being treated as if there was a lot of problems going on my side that I just wasn't doing my job, which was not true. In fact, I heard you mention Cheryle Davis. I worked for her, and she was fired by work. It wasn't until this Mrs. Briggs came in here, all of a sudden, I'm going from getting exceed standards to commonly ineffective, while my counterpart across the bay, with all these problems, continued to get exceed standards. And I don't see how they can say, my rights were violated. I tried to file a complaint. You expect that HR, EO is going to do what they're supposed to do when you come in there. I got the idea after a while that they were litigating against me. They were protecting management and not protecting my rights. I just, to me, it's a shame the way they treated me, and I know a number of people like that. As a matter of fact, they were telling me, oh, you can't file a complaint for someone else, and I wasn't doing that. I was giving examples. I gave an example of other people that were having problems in the same department, where there was racial slurs being thrown around at the operation, at my sister operation. There was racial slurs being thrown around. And I guess they said that trivial, isolated incident doesn't amount to harassment. To me, how do you make that decision? How do you make that decision that doesn't affect me or shouldn't affect me? As a matter of fact, one of the ladies, like I said, she tried to get reinstated. She wasn't reinstated. She was upset because the supervisor over there referred to me as buckwheat, and they were told about this, but. It's like it went in one ear and out the other. They didn't want to listen to it. They didn't listen to it. They just want to wait you out. And I don't think that they're treating everybody fairly, especially when you file a discrimination complaint. Because like I said, they told me that, oh, you can't file for someone else. But then they proceeded to, discuss that in the letter they sent back to me about, the fact that this was an isolated incident. And like I said, there's a lot of things going on that they just did not want to address. And they're just waiting for me to drop this and just not come back at them. And a few times I was going to do that. I was so frustrated.
Probably have some other things to say, but I really can't come up with them right now.
But like I said, they didn't treat me fairly when I filed my complaint. It's obvious. Like I said, they threw it away. And how does a place like a city that's supposedly known to stand up for the underdog, for their employees, how do you do something like that? And how can you, as a director, as Micki Callahan, see that and just ignore it? I guess that's all I have to say right now.
Thank you, Mr. Cunha. Okay, thank you very much. Colleagues, any questions, Mr. Cunha? Okay, now we'll hear from the department, please. Thank you.
Good afternoon, Commissioners. My name is Kimberly, K-I-M-B-E-R-L-Y, Love, L-O-V-E, and I'm an EEO Program Senior Specialist with the Department of Human Resources. Appellant Demetrius Coutinho was a superintendent of water treatment facilities with the San Francisco Public Utilities Commission until he retired on March 26, 2016. Mr. Coutinho made 3 EEO complaints regarding the same issues. The first was when he was still an employee around March 2015. Mr. Coutinho told Byron Shaw, a former personnel analyst with SFPUC, that his manager discriminated against him due to his race, and that he heard secondhand that another supervisor made race-based comments to Mr. Coutinho's coworker, an African-American female senior stationary engineer. In August 2015, Mr. Shaw left city employment without reporting Mr. Coutinho's complaint to the Department of Human Resources. After his retirement, Mr. Coutinho made a second complaint in early 2017, repeating the same allegations against his manager and allegations on behalf of his former coworkers. Mr. Coutinho also alleged that he was forced to retire earlier than he intended because SFPUC did not investigate his first complaint. Mr. Coutinho's complaint was closed because it was untimely, did not fall within EEO jurisdiction, and did not raise an inference of discrimination. However, because Mr. Shaw did not properly report Mr. Coutinho's complaint, SFPUC reviewed its complaint process to ensure that all complaints are documented and forwarded to DHR EEO. In addition, SFPUC now has a dedicated EEO program senior specialist who works only on EEO and reasonable accommodation matters. On June 29, 2017, Mr. Coutinho made a third complaint, which is the subject of this appeal. Mr. Coutinho alleged that there were racial slurs being used at a treatment plant. Although he initially refused to provide any details, Mr. Coutinho later alleged the same facts that he did in 2015. Mr. Coutinho also alleged that because SFPUC did not report his 2015 complaint, he was prevented from filing a complaint with the DFEH or the EEOC. However, documents show that in 2015, Mr. Coutinho was aware of his ability to file a complaint with the DFEH and the EEOC, and that the city informed Mr. Coutinho of his ability to file a complaint at least 4 times. On October 23, 2017, the Human Resources Director informed Mr. Coutinho that based on the information he provided, his allegations were untimely and insufficient to raise an inference of harassment. Mr. Coutinho appealed that decision. The question on appeal is whether the Human Resources Director appropriately administratively closed Mr. Coutinho's most recent complaint without further investigation? For the reasons I will explain, the answer to that question is yes. With respect to his harassment allegations, Mr. Catino alleged that his African-American female coworker reported an issue regarding racial slurs to SFPUC Human Resources. Mr. Catino's coworker left city employment in September 2013, so these allegations were untimely even in 2015. In addition, Mr. Catino did not hear the comments and did not provide information that was new or different from his 2015 complaint. Although Mr. Catino alleged that the comments were ongoing, he could not provide any specifics and acknowledged that he learned about the information secondhand from his coworker, who has not worked for the city for 5 years. In addition, on January 5th, 2016, Mr. Catino's coworker made a complaint of discrimination based on race and sex with the DFEH, but she did not make any allegations regarding racial slurs. The DFEH later dismissed her complaint. In conclusion, Mr. Catino's complaint did not allege facts to raise an inference of harassment. Therefore, the Human Resources Director correctly determined that his complaint should be closed without further investigation. We respectfully request that the Commission deny his appeal and uphold the Human Resources Director's determination. Justine Hinderleiter, Deputy Director with SFPUC Human Resources, is also here to answer any questions that you may have. Thank you.
Commissioner Sells.
Yes, I had questions for you, Ms. Love. In the early 2017 complaint, which I believe you sent the closeout letter on,
Yes.
I'm wondering why that wasn't sent by the DHR director, as is normally the course of business.
The Human Resources Director sends out the letters when matters are within EEO's jurisdiction, and that matter, because it was untimely and outside of EEO's jurisdiction, was sent by me.
And that complaint raised the complaints that he had made in 2015 that were ignored by Mr. Shaw, is that correct?
Yes.
I find that very troubling. that, because he made a complaint that was ignored, that somehow it's untimely when somebody finally, actually looks at it and responds to him. Do you have any comment on that?
Well, our practice currently is to have those letters come from Micki Callahan currently. At the time, that was not our practice, and it was not only that it was untimely, it was also that the allegations were outside of our jurisdiction. So the specific allegations that he was making regarding his manager were things that were within his manager's jurisdiction, so to speak. For instance, that he decided he couldn't appoint an acting manager, or those sorts of things.
If the manager made those determinations based on race, that would be inappropriate, wouldn't you agree?
I would, except Mr. Catino did not provide any information to support that allegation. There were no other comments or other information to support that causal link.
He did make allegations that in certain cases, he believed that white males were treated differently. This is with respect to the, what was it, the 500-gallon, 50-gallon thing. And there was another item, for the evaluations, he felt that a white male had been treated differently. So he did have those allegations as part of his report to you.
Yes, with respect to the discharge, though, Mr. Catino acknowledged that he did make a mistake and he was responsible for that mistake as a superintendent.
Yeah, but I believe the allegation was that similar discharges that were supervised by white males were not subject to investigation. Or is that how I read it?
I don't believe, and I could be mistaken, but I don't believe he provided a comparable example. he was using that discharge as an example of why he felt he was being singled out.
Perhaps you can respond to that in a moment, but I had another question for you, which was, in your letter, your closeout letter to him, you didn't mention any ability to appeal to the Civil Service Commission. Was that a mistake, or what do you say about that?
The process that we had at the time is that if a letter comes from Micki Callahan, then appeal rights attached to that letter. If it comes from an investigator because something is outside of our jurisdiction, then appeal rights do not attach. So we would not include it in the letter.
Okay.
Well, I was going to ask him to respond.
Okay.
Can I speak
Okay,
up?
please. Please.
Okay. Her saying that, I'm sorry, Demetrius Castillo. Yeah, her saying that they had informed me of being able to file appeal. We all know we can file appeal with the state. That was not the issue. The issue was the timeline. The Officer Benshaw did not provide me with the timeline. He said nothing about that. What they want to do is absolve him from doing his duty by saying that I had taken certain courses as a supervisor that would tell you that. But that is not something that I do on a daily basis. That does not absolve him from telling me what those timelines are. And that's what he did. And I did give them, like as far as that spill, she said that I admitted to making a mistake. I didn't admit to making any mistake. What happened was, it wasn't spilled into a containment area. It was into a containment area. My guys neutralized it before it was pumped out to the lake. So it wasn't a mistake. They did what they had to do. Plus, I told my supervisor and showed him that in our discharge permit, it said anything under 1,000 gallons was not reportable. I mean, any discharge under 1,000 gallons not reportable. In the meantime, across the bay with my counterpart, there were thousands of gallons of spill over there, and the city paid some hefty fines for that. But he comes to me with my supervisor, a person from natural resources, and another engineer grilling me, my immediate, my chief supervisor, my senior, and the operator. All of that, and they never did anything like that on the other side. So they're not being truthful with what they're saying here. Because like I said, I told them what I was doing. And as far as the timeline, like I said, each time I went and told them about this, and it was always ignored or forgotten. And I go back to, like I said, how do you throw away a complaint and then try and tell me that I was treated fairly? And like I said, as far as, my reputation was good, which that suffered during that time because, like I said, I had a lot of authority stripped from me. Like I mentioned the R&R funds that I used to administrate. It was always administered by a superintendent. Well, he took that from me, didn't tell me why, he just took it from me and handed it to my supervisor. Then later on I found that, they pretty much did what they wanted with that money. To avoid coming back to the commission and asking for more money on the project, they just rolled that money over into that project. I mean, a lot of things they were doing was it just wasn't above board.
Mr. Castillo, one of the points that I was discussing with Ms. Love was whether or not you were alleging that with respect to the discharge, whether there were similarly situated white males who were not investigated but who were responsible for discharge.
Yes, and that was my counterpart on the other side. Like I said, the city pays some hefty fines for those discharges. But because I even called over to ask, I said, hey, did they do this to these guys over there? There's nothing like that done. He didn't send all the people over there to, what do you call it, grill them on all of that. And like I said, and for them to ignore me telling them the racial issues across the bay, for them to ignore that, decide they weren't going to do anything about it. I mean, the same supervisor, he had a poster in his office
President Obama on a food stamp. And, you know, and they act like that was no big deal. So, like I said, to me, they're not doing their job. They don't have enough people. They don't have enough people there who understand what discrimination is. And I question the diversity of the people in decision-making positions there. I know there's a lot of lawyers there who seem to think that their job is to protect management and not the employees.
Just one of the things, Tina, this comes to us as an appeal on a closure of your complaint. Are you seeking the remedy of us directing DHR to do an investigation of your complaint because they have not investigated it? They've determined that it didn't warrant.
From what I can see, they had their mind made up from the start. And when I met with Ms. Love here, I didn't get the idea that you know, they really plan to do anything about this. Like I said, they made up their mind already. So as far as any investigation being this, I mean, I gave them all the issues that I had. They didn't investigate it. Like I said, the guy just threw it in the garbage. So they had no intention of investigating. That's probably why he never even told me what the timelines are, because he had no intention of doing anything with that. And like I said, they called him and asked him, and he lied about that. And it wasn't until I was able to get those emails to show that we were in correspondence about this.
One question. Physically destroy, get rid of, throw away, personally?
I didn't know. I didn't see him. All I know what happened was when I went back to file with them, they told me that there was nothing filed. That's how I found out about it. I didn't know. I thought I was under it because of the fact he emailed me back saying I'm investigating. And then he also had the nerve to tell me when he was talking to me saying that, well, you're the only one complaining. Like that should make a difference. And how does someone in HRDO have that type of mindset? You know, because there's a lot of people that want to complain, but they're worried about their jobs, worried about how the supervisor's going to treat them. Because like I said, there's retaliation that's going on also.
Okay. Mrs. Betty, Commissioner.
Yes, I have a question for the department. PUC, or Representative Silva from PUC. So you had said that you have corrected your procedures with regard to the EEO receipt for complaints, and you've added staff. Is that what's happened? Or?
Yes. Hi, Justine Hinderleiter. I'm interim HR Director with the PUC. So since the time of this originally happening, we had our employee relations and EEO function, ADA function were held by the same people. So we have now bifurcated that essentially, and employee relations is one set of staff, and EEO ADA is coordinated by a 1231 senior EEO specialist.
So they're focusing. With regard to the unit that he was complaining about, have there been any follow-up to address some of the issues that were expressed?
You mean within HR or where he worked?
Where he worked.
Well,
the entire department. I mean, what is going on with regard to what kind of, is there any kind of follow-up on, because they're rather serious complaints, even though they may have been untimely, but has there been, what kind of follow-up has been within that department?
Well, we always roll out, as required, the training that is required for supervisors, and that's PUC-wide, so that would include any supervisor or manager position within the Water Supply and Treatment Division, which is the division that Mr. Coutinho was with. Additionally, through this complaint process with DHR, they looked at emails, they looked at the information that Mr. Coutinho gave, but to the best of my knowledge, it's not like there was a wholesale approach to discuss this matter with the division, if that's what you're asking.
That's what I'm asking. So there's not been any real, I would say, focus perhaps with regard to the complaints that were filed, or the comments that were made, and more specific information with either the individuals against whom these accusations were made or any of the other supervisory staff with regard to his complaint?
Not to the best of my knowledge. The supervisor or manager that he was complaining about is no longer with the PUC. So no, not to the best of my knowledge.
Has there been any measurement of the culture in the department, the department?
We recently did an employee engagement survey within the PUC, and that was agency-wide, basically to gauge the temperature, if you will, for a number of factors relating to employee engagement. And so it was voluntary as far as participation, but we did have a pretty good participation rate, PUC-wide that is. So we're in the process. It was a very large survey. We had about 63% participation, and which we're very pleased about. And we have just under 2,300 employees, so that's pretty big. And so we've over the last 6 or so months, we've been going through those results, and each manager and supervisor goes through those results. And so this is one way to use data-driven information to understand cultural issues, in addition to a number of other data points that are important for employee engagement. So yes, we have been really making a concerted effort to understand cultural issues, if you will, from throughout the agency.
With regard to the supervisory staff of the area that Mr. Coutinho worked, has that been 100% turnover, or are there still individuals remaining?
I guess it would depend on what level you're talking about, but the manager for the that Mr. Coutinho reported to, he's no longer there. Obviously, Mr. Coutinho's no longer there. There was, and I'm not quite recalling the hierarchy, but I believe kind of in between those two levels, that person also retired. So this is not unique to water supply and treatment. This is not unique, frankly, to the PUC. This is a phenomenon that I think most utilities throughout the nation are facing, that there's really a high level of retirements on the horizon. So I don't know the specific answer, but there has been a fair amount of turnover.
The response to Mr. Coutinho's complaint in early 2017, I believe your letter indicated his claims were untimely. Is that correct?
Yes, they were.
But you went through and discussed them substantively. But were they untimely because they weren't addressed in 2015? I mean, if they had been addressed in 2015, would you have considered them timely?
If they were addressed, I'm sorry, could you repeat that?
Well, you said his claims were untimely in 2017, but he tried to submit them in 2015. So what I'm asking you to do is to kind of go back in time and say, if he had actually got someone to take the complaint then, would that have been timely in your view?
Well, if in 2015 this complaint was properly reported to us, we would review his allegations. Generally, we look at the past 6 months. However, if there's some sort of continuing pattern, then we would look at the full scope.
Follow up on that. And if it had been considered timely, and what kind of recommendations would you say, for example, it didn't rise to the level of discriminatory action, but still you saw or heard what was happening, what kind of action would you have taken then?
Under this circumstances, since it does not appear that Mr. Coutinho was adversely affected by the allegations that he made with respect to Mr. Briggs, I would have made the recommendation that perhaps Mr. Briggs should have been counseled regarding the EEO policy and reviewed that with personnel.
Colleagues?
Would you have recommended any training, additional training for the unit?
Well, this is a little a trickier complaint given that Mr. Coutinho was a superintendent. So he's high up there, he's reporting to one other individual in the plant. So when we're looking at training, people like Mr. Coutinho and his supervisor, they are receiving harassment prevention training. And as Justine discussed, there's other training that PUC gives as well.
Once again, Demetrius Coutinho. Yeah, I did give them names of people that could verify about those racial slurs and things that were going on. I gave them a list of names, and they did nothing with that. So I did give them information that they either filed somewhere or didn't file anyway, they just ignored it. So I did give them names. And let's see, there was something else I wanted to mention. Oh, where was it? Oh, I can't remember what it is now. Like I said, I want to go to full term to my complete retirement, 62, 2.3 and 62. Well, because of the fact that they did not pay attention to that, I wasn't able to get that. I wanted my retirement to be adjusted to reflect that other year, and also the back pay for that time that I would have missed, and also in my ex-wife's to be adjusted because the retirement she gets is based on what I have. So if I'd had that extra year, I'd have gotten more on my retirement, she'd have gotten more.
And I feel that his complaint that he tried to make in 2015 appears to have had enough merit to it, although it's through no fault of his own, it wasn't addressed back then. And now here we are in 2019. And I feel that in order for the complaint process to be supported adequately, I think in this case, although it's unusual, I would say we should grant the appeal and direct the department to do an investigation of the claims that he made going back to 2015. I feel that given what he has experienced and gone through, that he should get that, even though I think there's a close question as to whether the allegations he made will actually result in a finding. I think that there ought to be an investigation. He should not have been turned away in 2015, and I don't think we should turn him away here.
I would agree and promise, except I would like to narrow a bit, because to me there's a lot of unsubstantiated word of mouth. That one said, but focused primarily to the appellants and how this has affected him, and investigate that.
Yes, I agree with that. I believe that the investigation should be focused on actions that were directed to the appellant, and that it could be considered whether there's evidence that the Mr. Briggs, what he's complained about, has engaged in any statements or activities that would show a racial animus. But yes, I believe the investigation should be focused on the conduct that Mr. Patino experience that he has complained about.
I agree with that. You vote, I'll second.
Wait, public comment.
Or the spillage and discharging comparative, whether or not the person in the East Bay, who happened to be a white male, had a different penalty assessed or no penalty as compared what happened to him compared to Mr. Patino. The other, though, is that I would like to be able to see, I understand we have our annual training, and I find those annual trainings to be very useful. But sometimes when you've got a unit where, I mean, this may be part of a remedy, perhaps, eventually, I would really like to see more in-depth training of the particular unit that Mr. Patino was running. But that may be something that's gone down the road.
But with that, I mean, procedurally, I would suggest that would be a mandate from the substitution department. And sort of, it's tangential to the case, but to the motion, I think it's not in my mind necessary to attach it to the motion.
All right,
I think we're taking care of the appellant first and then the second.
I agree with that. I believe that after the investigation, depending on the results, if we see it again, we could consider whether further remedies are necessary.
Okay.
So,
The allegations that Mr. Coutinho made regarding the racial comments were not made by Mr. Briggs. They were made by another individual, and Mr. Briggs is no longer an employee of the city.
To send me home because I had just been operated on my wrist and couldn't do the work because it was going to be loss of filing. And then when I went back 3 months later, they placed me at a desk with no telephone, no computer, on it was a keyboard. And on top of that, they had a temporary subcontractor who was at the same level as myself, and I was told that she was my supervisor. So I do hope that they do train all these supervisors at the UC.
Teresa Rutherford, SEIU 10-1. I do not represent this brother. However, I think the issues that he has raised are so, reflective of the systemic racism that we keep speaking about. And one of the things I appreciate your comments, Kate, Elizabeth. I really appreciate the fact that you have listened and that you really saw through the screen and the mirrors where clearly he had an issue, he raised the issue as African Americans do to say, I'm being mistreated, I'm being singled out, I'm being discriminated against. And the standard system is to trivialize it and to say you're playing the race card. People don't understand how, racism impacts the African Americans' health. Women, we have enough studies, we know that women lose their children, African Americans lose their children, lose their babies because of the stress they're dealing with this intrinsic racism. They see it when they go to the hospital. You are treated like that when you face the police. You're treated like that by your supervisors. It is not enough to hear, there is not enough evidence. How much evidence do you need when someone calls you buckwheat or nigger? Come on now. So I am glad that you're paying attention, and it merits. I think you should look at his health record because it plays into the whole effect of racism on us. I've seen so many people end up in the hospital, end up walking away from their jobs because they can no longer fight the system. And so I appreciate that you're paying attention to this gentleman. And it's not going to be the first time you hear this, but one's health issues play a big part in looking at racism because it impacts our health. It impacts the worker's health. You cannot continue to work in an environment where everyone treats you like nothing. And that's what's happening here. So I appreciate that you're paying attention to this. I'm asking you to hold it, because one of the things I'm hearing from the presenters also, it's almost as if, you know, they are not understanding that this is systemic and that there is a value in looking at what he says. It's almost as if he did not have all his dots, his T's crossed and his I's dotted, and therefore you throw it out. That's not good enough. That's not good enough if you're sincerely looking at a system, you're trying to create justice, you're trying to create fairness, and you're acknowledging that racism exists. And to address it, we must be proactive, deliberate, and make sure that we really look and do the right thing. So, you know, again, the same old. I'm glad you're paying attention, and I do trust that you will move forward honorably, but also move forward as citizens of this country to make this change. It starts here. Thank you.
My immediate impression of the case was, and if we're going to revisit the matter, one would hope that Mr. Castillo secures himself adequate representation in order to frame the matters that would be able to satisfy what I believe to be the predicate allegations and showing the proof necessary in order to create state a cause of action that is membership in a protected category. He suffered adverse employment action, and it was related to his membership in the protected category or somehow retaliation for exercising a protectable right. What we do see on this administrative record before us, notwithstanding the invitation by members of the public that we engage in a public policy or investigative activity that I believe would be beyond our jurisdictional purview, is that the supervisor in question, Mr. Briggs, it has been alleged that he had removed the ability to appoint persons acting positions, but there was no evidence that he had exceeded his authority or that job bidding and plan schedules, while they may reflect a difference in management style, that does not in and of itself, as alleged, raise an inference of discrimination. Moreover, there appears to be no evidence on this administrative record that Mr. Briggs had directed a colleague or subordinate to provide the performance ratings to the appellant on account of his race. However, my point of view, I think in order to approach or to accommodate the remedy sought by the appellant, I certainly would be interested in determining or having an investigation that could be responsive to the allegations of constructive discharge, whether or not the conditions or the actions or the events at the SFPUC had created such an environment or allowed working conditions to become, as a standard, is so intolerable that it caused a premature retirement of the appellant because of these intolerable conditions. We do have a paucity on this administrative record that the alleged conduct does not appear, at least at this point in time, to be objectively based on the appellant's race, but I would hope that the further inquiry that would presumably flow from our taking positive action in favor of the appellant would help explain what in fact occurred. So while I'm a bit skeptical as to the ultimate merits of the appellant's case, I'm prepared to support the motion.
Question. Commissioner Vetti. Okay, Mr. Callahan, I'm sorry, I didn't see you. Why not?
Demetrius Coutinho again. These are my blood pressure records. Can I give those to you, or? it shows, you know, what I was going through, what my blood pressure was doing during these times. This is going back to 2015.
President, if I may, as a matter of point of order, I think this attempts to introduce matters that would be more appropriate to a hearing on the merits. You're not here today, nor is the motion designed to address that procedurally, whether or not to grant the appeal to allow the expanded proceedings that the appellant seeks to go forward.
Okay. Commissioner Salson.
I would encourage you to submit those in connection with, if the motion passes, with the investigation.
Okay. And you mentioned getting representation. As far as I can understand, EO and HR was my representation. And why should I have to spend money to go out and get somebody to come and represent me? I mean, EO was supposed to be up forthright when it came to dealing with me, you know, and they just weren't. So now I need to spend money in order to get them to do what they should have done in the first place.
Thank you.
Okay, thank you.
Okay, yeah, so before us, we've heard public comment, testimony, I believe that's over. I'll entertain a motion. Oh, okay, so you want to restate the motion so we're clear on?
The motion is to grant the appeal, to direct DHR to investigate Mr. Coutinho's claims of discrimination and harassment as they relate to him, and that the investigation extend to those allegations that he made as to discrimination and harassment against him that he made back in as far as 2015.
Second. Okay, so been moved and seconded. All those in favor, please signify by saying aye.
Aye.
Any opposed? You guys have it, so ordered.
Commissioners, my name is Concy Jones, and yes, SEIU has asked that we reschedule.
Hello, Commissioners. My name is Hector Cardenas. I'm representative with SEIU Local 21, assigned with the SFMTA. And I want to echo SEIU Local 21 Vice President Teresa Rutherford's public comment that a proper, informed review is necessary, and the SFMTA has not provided a request for information submitted in behalf of Concy Jones regarding this item on the agenda. We believe that we need more time to receive and review the pertinent information requested so that we can appropriately address this submission. SFMTA has asked for an extension to provide the information requested. I have provided that email previously, and we respectfully request to hold this item until February 4th meeting to allow time to receive this information from the SFMTA that we would need to review.
Yes. I'm not aware of that. So with that, is there someone here from SFMTA?
Yes, sir.
Okay. Are you prepared to continue?
Hello, Julie Kirschbaum, I'm the Acting Director of Transit SFMTA. We are prepared to speak to this item, but I'm not personally aware of the public records request and cannot speak directly to that.
Okay. Thank you.
Good afternoon, Commissioners. Vanessa Doyle from the Department of Human Resources. I'm also not aware of any requests for information from the appellant today. At the last hearing here on December the 3rd, at the time the appellant had asked for postponement for several months. We'd agreed to postpone this hearing until today's date. And appellant, as of this morning, has again requested to postpone the appeal. We are prepared to move forward today, and we do wish to continue this hearing.
Okay. To the appellant, did you request in writing? And when?
Yes, we requested it in writing, and there's a communication from Employee Relations Specialist Parveen Boparai requesting an extension with an undefined timeline.
Yeah, what? The question is, what information specifically are you requesting from the SSMTA?
We're requesting a variety of pieces of information because this complaint is a portion of this complaint is the switching around of several employees in various units under Ms. Kirschbaum's management. So we would need to know more information about how these moves were made that actually affect the decision made to remove Ms. Conzi from her position in the unit.
These were in writing? Well, that's what I asked. Was that in writing?
Yes, yeah, we do have if the commission would like to see this request for information, although I would venture to say we would actually appreciate the commission's nudge on SFMTA to provide this information. That would be most helpful to all of us. But anyway, yes, requested in writing, and we have provided the email from Ms. Perrine Boparai requesting an extension to be able to provide the information to the union.
Thank you. Commissioner Huffle.
When was this made?
It was made about September, October, more or less.
The request for information was filed in September, October?
As far as my knowledge, there's a request for information submitted there. I believe there may be another one actually that was filed with the
Why didn't we
grievance.
discuss this last meeting when we considered this case? Why wasn't this brought up?
I'm sorry?
This was...
The question before us is, we granted a continuance, and at that time we asserted to you that we need to have some movement on this and granted the request for postponement so that you could appropriately get together with the parties and have the information available to you. Are you sharing with us you're not getting it from an appropriate party, that a specific request was not granted?
That's correct. It hasn't been provided the only thing that's been provided is a request for an extension to be able to provide the information requested from us, from the union.
Was there any mention of this? Is my memory on that last meeting when we gave the extension?
I have a recall for more time for information to be granted, but other than that, I don't have a specific recall for, unless my colleagues want to chime in. Okay, let's hear from the department then.
Vanessa Doyle from Department of Human Resources. Again, we request to move forward with the matter today. Any request for information regarding the appellant's move from, I believe this is the move from the Castillo to the TMC, is irrelevant. As that move occurred after her complaint was filed. That issue is not before the commission today, and therefore it's not relevant to any request for an extension.
Okay. On behalf of the union, do you understand and agree with that statement? Oh, I understand.
I understand we disagree.
Okay, thank you. Colleagues?
Actually, I'm inclined to go forward. We're voting in with one extension. And you're saying that this request is not relevant to what we have today. So it could possibly be the basis for another that would be investigated separately.
Exactly, Commissioner. So this move from the appellant's move from the Procedural Division to the TMC, that occurred after the original complaint was filed, and therefore is not the issue on this appeal.
I would concur with that and support a motion to move forward today.
Okay.
I move we deny the request for a continuance and proceed with the hearing.
Okay.
Second.
It's been moved and seconded. All those in hearing this complaint today by the appellant and the department, please signify by stating aye.
Aye.
Opposed? You guys have it.
Again, my name is Vanessa Doyle, Vanessa Doyle. I am an Equal Employment Opportunity Program Specialist with the Department of Human Resources. I am here to respectfully request that the Commission uphold the Director of Transportation's decision that Appellant Conzi Jones's discrimination and harassment complaint did not warrant further investigation and denied her appeal. Since 1995, Ms. Jones has been employed at SFMTA, and since October 2018, she's been a 1446 Secretary 2. Previously, from September 2015 to October 2018, she was an 1840 Junior Management Assistant in SFMTA's Transit Division. On April 19, 2018, Ms. Jones reported to SFMTA EEO that various current and former transit managers subjected her to discrimination and harassment based on her age. The specific conduct that Ms. Jones identified was discussing work assignments with her, giving her work assignments she disliked, reassigning some of her work assignments to others, transferring her work location, asking about her whereabouts, throwing away documents Ms. Jones had requested be signed, and requiring her to have a work cell phone. Ms. Jones acknowledged that all respondents are also over 40 years old, and everyone except Julie Kirschbaum is about her same age. Ms. Jones alleged that, quote, younger planners, unquote, supervised by Ms. Kirschbaum, have been promoted, and SFMTA recently hired many, quote, younger people, unquote. Additionally, Ms. Jones alleged that John Haley tried to push out David Banbury, Mary Travis Allen, and Francisca Tapia, so in turn they tried to, quote, put the heat on her, unquote, to deflect it from themselves. By letter dated August 28, 2018, the Director of Transportation notified Ms. Jones that based on the information she provided, her allegations did not warrant further investigation and her complaint would be administratively closed. In her September 14, 2018 appeal, Ms. Jones restated her original allegations and added that the conduct continued through September 2018. For the first time in her appeal, Ms. Jones alleged the conduct may have been due to her race. While this issue is not before the Commission, we are addressing it with the appeal. Some of Ms. Jones' allegations, if true, violated the city's respect policy. SFMTA took appropriate action to address the alleged conduct. The issue on appeal is whether the Director of Transportation appropriately closed Ms. Jones' complaint, EEO file number 2747, without further investigation. For the following reasons, the answer is yes. Ms. Jones alleged that SFMTA management subjected her to discrimination due to her age, race, and years with the agency, but none of the conduct she identified constitutes an adverse employment action. It is within management's purview to make and discuss work assignments, issue workplace directives, inquire as to her whereabouts, and request that she have a cell phone. Further, none of the alleged conduct is connected to her age or race, nor did Ms. Jones allege she was treated less favorably than similarly situated employees based on her age or race. Ms. Jones also attributed the conduct to managers wanting to put the heat on her to deflect it from themselves, which is not a protected category. Therefore, further investigation of Ms. Jones' discrimination allegations is not warranted. Ms. Jones' allegations were also insufficient to raise an inference of harassment. Again, she provided no information to support her claim that the conduct is related to her age, race, or membership in any other protected category. While Ms. Jones was displeased by her interactions with SFMTA management and their decisions regarding work assignments, the conduct she alleged does not raise an inference of harassment warranting further investigation. SFMTA has already taken appropriate action to address the conduct that, if true, violates the city's respect policy. Ms. Jones has provided no relevant information that should cause the Commission to overturn the Director of Transportation's determination. Rather, she restated the allegations that she previously reported and alleged the same conduct continued through August 2018. But as already discussed, Ms. Jones' discrimination and harassment allegations do not warrant further investigation. In conclusion, Ms. Jones' April 2018 allegations did not warrant further investigation, and on appeal, she has provided no information to conclude otherwise. Therefore, we respectfully request the Commission deny Ms. Jones' appeal and uphold the Director of Transportation's determination. I'm happy to answer any questions you may have. Also present today is Julie Kirschbaum as a representative from SFMTA, should you have any specific questions for the Department. Thank you.
Thank you. Okay. Happy to hear unless the questions, I'm sorry, really, let's have questions.
Just a question. I noticed in the materials that there was a feeling on the part of the department that some of the conduct, even though it was not, didn't rise to the level of age discrimination or harassment, was deemed potentially violative of one of the city's policies, and that corrective action was taken. Can you expand on that?
Thank you for your question, Commissioner. Yes, that's correct. So the allegations that were possible violations of the city's respect policy were in one instance throwing away documents in response to the appellant asking whether they had been signed. And the other instance had been a manager touching the appellant's arm to direct her to a file. Although no investigation has been done to determine whether the conduct as alleged is true, the conduct, if true, would be inappropriate and would be a violation of the city's respect policy. SFMTA took appropriate action to address the alleged conduct by following up with the accused and managers regarding the allegations.
Not really, in fact, Commissioner Solomon asked two questions.
Okay, right. Should we help out? Okay. Thank you very much. We'll go from the appellants.
Good afternoon, Commissioners. Thank you for letting me share my presentation with you. My appeal dated September 14, 2018. I provided factual situations highlighting discrimination, harassment, and bullying by Ms. Kirschbaum that substantiate the following issues giving rise to my complaint. Excluding me and stopping me from working with colleagues and taking part in activities that relate to my work assignments, lack of communications, playing mind games, using other colleagues to unite against me, and other types of psychological harassment like my need for a cell phone. I was constantly harassed to get a cell phone when I was always at my desk and was always reachable via email. There was no need for a cell phone. However, to comply with Ms. Kirschbaum, I did get a cell phone, which she only used maybe 5 times since she had requested that I get the cell phone. She assigned trivial tasks. One of the tasks was copying all the transit training materials for binders, which was quite a large endeavor. That assignment also assigning me relevant assignments that was not relevant to my class series scope of work, physical work, projects assigned to be performed by myself without having the items needed to move large boxes from the MME facility out on 3rd Street all the way to the TMC. She said she wouldn't give me time to make arrangements with our real estate department to schedule movers, so therefore I had to find a way to move all this stuff by myself. She also issued difficult tasks that couldn't be done in the allotted time frames as necessary, like the printing of all of the transit materials. I found out about it later. She came up to me 2 weeks later and told me to follow up on an email that she had sent to all of the divisions to get their training materials. And by this time, the project was due ASAP, which I followed up on, and I worked as hard as I could day and night to comply with this assignment, only to find out that after the completion of putting all these binders together, we're talking 3-inch binders, and there had to be at least 10 of them, and they had to be separated and divided. I didn't have enough time to get the appropriate materials or the dividers that I needed. I had to put in a special request to try to get the things delivered overnight so I could accommodate the request, and come to find out it wasn't really needed. She deliberately held back information needed for me to perform my assignments. She issued a capricious reassignment of work locations in violation of my MOU when she relocated me to the Procedural division. She took away a lot of my duties and assigned them to higher classes that I have been performing for 5 years or more. And the retaliation for participating in the grievance process by decreasing my work duties and assigning me yet a second time in a 1-year period. In July 10, 2017, Ms. Kirschbaum was appointed Chief Transit Officer, replacing Jeff Lynn. At this time, I had approximately 54 job assignments and tasks, which also included special projects that I had been assigned to perform specifically for transit operation. Within that year of her acting assignment as Chief Transit Officer, Ms. Kirschbaum took away all my job responsibilities, attempted to resign to the Procedural division as an 1840 Junior Management Assistant, which finally has culminated in the recent removal of my 1840 PEX appointment I held for over 3 years as I worked on the long-term assignments, Project Race for Zero, as well as working on redoing the entire filing system for all of the 7 divisions, standardizing all the filing procedures. She has returned to my previous 1446 class and has reassigned me out of transit back to capital programs and construction, CP&C, as a receptionist. Refusing to renew or extend my 1840 appointment so that I could complete the projects previously assigned to me, which includes the coordination of Race to Zero. Although Ms. Kirschbaum claims that the new reassignment to CP&C, which went into effect October 22nd, 2018, was a result of the expiration of my 1840 Junior Management Assistant assignment with Transit, I truly believe that this is in prejudice and retaliation of my Step 3 grievance previously filed against Ms. Kirschbaum that was upheld and settled by DHR, returning me from the Procedural division back to the TMC. This new reassignment is also done, I feel, in retaliation since I filed a DHR complaint against her for constant discrimination, harassment, and bullying, as well as the reassignment to Procedural and the grievance that I filed. Ms. Kirschbaum would not work with me as her assistant. Then after trying to overwork me with additional assignments for street operations, which they had their own 1840 who was very competent and could take care of his own assignments, then she began to exclude me from everything that I had been assigned to work on prior to her appointment as Chief Transit Officer, as well as excluding me from colleagues, disconnecting me from all of my projects and all the achievements that I had made within transit operation. During my year with Ms. Kirschbaum, as well as to this day, the effect of Ms. Kirschbaum's constant discrimination, harassment, and bullying has had an impact on my health, which includes unwarranted stress, high anxiety, headaches, backaches, trouble sleeping, and exceptionally high blood pressure. I hope you understand that I feel horrible, not only because of the unethical treatment that I had undergone for the past year with Ms. Kirschbaum. I feel bad that I even have to come and file complaints and make reports of such behavior that I had received by Ms. Kirschbaum. I'm truly suffering mentally, emotionally, physically, and morally. My morale is at an all-time low. I've been employed with SFMTA for over 20 years, over 23 years. I'm a good employee. I don't deserve the treatment that I have endured from Ms. Kirschbaum for the past year. And with this being said, I would greatly appreciate the CSC board's support and uphold my appeal, as well as move forward with accountability for the unethical treatment that I have suffered working with Ms. Kirschbaum. Let me just point out a couple of things to you which constitute workplace harassment that is applicable to my situation. Harassment is a form of employment discrimination that violates Title VII of the Civil Rights Act of 1964 and the Age Discrimination in Employment Act of 1967. Harassment is an unwelcome conduct that is based on, but not limited to, race, color, religion, and age, being 40 or older. Harassment becomes unlawful when the conduct is severe or pervasive enough to create a work environment that a responsible person would consider intimidating, hostile, and abusive. Anti-discrimination laws also prohibit harassment against individuals in retaliation for filing a discrimination charge, testifying, or participating in any way in any investigation or lawsuit under the laws, or opposing employment practices that they reasonably believe discriminate against individuals in violation of these laws. Offensive conduct may include, but is not limited to, intimidation as well as interference with work performance. Harassment can occur in a variety of circumstances, including, but not limited to, a supervisor in another area, an agent or an employer, a co-worker or a non-employee. As I am sure the board is aware, unlawful harassment may occur without economic injury or discharge to an employee. EEO laws are in place to prohibit punishing employees for asserting their rights to be free from employment discrimination, including harassment. Asserting my EEO rights is called protective activity, and it can take many forms. For example, it is unlawful to retaliate against an applicant or employee for filing an EEO charge or complaint. Communicating with the supervisor or manager about employment discrimination, including harassment. Participating in a complaint process is protected from retaliation under all circumstances. Other acts to oppose discrimination are protected as long as the employee is acting on the reasonable belief that something in the workplace may violate EEO laws, even if he or she does not put it in terminological states. Examples of retaliation acts from a manager because of the employee's EEO activity include transferring the employee to a less desirable position, escalating scrutiny, assigning an employee difficult tasks. And I would just like to point out that part of SFMTA's strategy plan, and I provided a copy of that in the additional documents that I submitted in its document number 12 on page 2. And it says, under strategic plan overview, it's workplace values, which includes the focus on respect, inclusivity, and respect. On page 20, under service, goal 4, create a workplace that delivers outstanding service. It states, investing in SFMTA workforce is a critical element to the overall achievement of the agency's goal and objectives. When staff has the resource and tools to succeed, they can become more efficient and effective and prepared to deliver services in support of all agency goals and objectives. These resources could range from physical safety equipment and project delivery processes and improvements, all the way to new community engagement training courses and professional development programs. Together, they will create a solid foundation for the agency's workforce and establish a baseline for how all team work together, communicate, engage with the community, and more effectively and efficiently deliver project services. Also on page 20, Objective 4.1, strengthening morale and wellness through enhanced employee engagement, support, and development. It states, improving the morale of the workforce will lead to greater staff engagement and overall greater ability to deliver community services and projects. Through ongoing efforts, including recognition programs, professional development, and training opportunities, the agency can move towards being a more collaborative workplace that trains and engages staff at all locations and all job classifications. As Ms. Kirschbaum's assistant and her direct report, I did not experience any of these commitments from her. To me, for employee development, she did just the opposite. All my work assignments, ideas, my creativity, and progress that I put into Race to Zero events, which I have been assisting and supported since its inception for over 8 years, as well as coordinating the 9139 graduation assigned to me by Ms. Kirschbaum herself for street operations. Ms. Kirschbaum took away Race to Zero from me. She took away that assignment, and she was adamant, extremely adamant, about me turning over all my templates that I created for the 9139 graduation events and taking away from me my accomplishments, all my achievements, putting together these programs, as well as coordinating these events. It was ripped away from me. This was time that I invested in transit. This is time and energy and creativity that I invested to help employee morale and to boost the frontline people. As far as collaborating with me, Ms. Kirschbaum wouldn't even work with me, refusing to sign important documents and throwing them in the trash in front of my face, and always tried to find fault with any and everything that I did, no matter how hard I worked to show her that I'll have her back and that I was working for her and for her success and to make her look good and to make transit look good. Didn't matter. She did not even as much as appreciated the sweat that I produced. Excuse me. As noted in the July 10, 2017 memorandum announcing Ms. Kirschbaum as the new transit officer, I provided a copy for you previously in my initial appeal, dated September 14, 2018. It's attachment 8, and in paragraph 3, it states, she, referring to Ms. Kirschbaum, is the consummate relationship builder who engages and values input from others and takes pride in delivering the program. Julie is committed to the principles of our strategic plan and leadership commitments and works tirelessly to accomplish them. On the contrary, Ms. Kirschbaum went out of her way to do the exact opposite with me while I was her assistant regarding how good I performed and at what level my work was. To address Ms. Kirschbaum's commitment to the SFMTA strategic plan, Ms. Kirschbaum is in conflict with the strategic plan and showed me no commitment as stated in strategic plan under objective 4.1, which is to strengthen morale and wellness through enhanced employee engagement, support, and development. I would like to just take an opportunity right now to highlight comments in my performance appraisal plan that I have received from the previous transit officer, Jeff Flynn. A copy has been included in the additional documents that I submitted, number 8, page 5. He writes, for fiscal 2016, Consi worked providing management assistant to Sarita Britt. In this role, she had to craft what she believed the job to be in light of challenging circumstances and limited direction. Kanzi excelled in providing this self-guidance and support to Sarita and Sarita's immediate subordinates, Mary Travis Allen and Lita Rosier. In the coming year, I would like to see Kanzi step into a more management assistant focus and work on major programs such as standardizing the operating division and ensuring uniformity in our programs, especially safety-focused ones and practices. Kanzi has already shown herself this new fiscal year to be a leader and a teacher to other administrative staffs. So again, I can't stress to you enough right now how awful I feel because of all of the unprincipled treatment that I experienced for over a year working with Ms. Kirschbaum. I feel bad because I even have to file complaints, that I even have to report such behavior amongst management. This is not easy for me. And again, I stress to you, I'm suffering mentally, emotionally, and physically through this whole process. I've been employed with SFMCTA for over 23 years. I'm a good employee. I don't deserve this treatment that I have endured over the past year. With all this being said, I would greatly appreciate the CSC board to please support and uphold my appeal, as well as move forward with accountability for an ethical treatment that I have suffered. And it's not only me, there's others. They're just afraid to speak up. But I thank you. I thank you for letting me speak my piece today. Thank you.
Commissioner Potero.
Yes, Ms. Jones, I had a question for you. Actually, we appreciate all the efforts that you make. It's obvious that you have your heart in your job. But I wanted to clarify something that you addressed it towards the beginning of your presentation. And it had to do with your 1840 position. You were a PEX, permanent exempt.
Permanent exempt, that's correct.
Were you on a special project?
Yes, I was on several special projects.
Okay, I need to clarify something for you. Special projects, and I want to confirm this with the MTA. You're on a requisition that's under a certain charter section that is special projects. There is a limit of only 3 years, and there's no allowance for extension. And I wanted to make sure that you were aware of that.
That I was not aware of because I was told in the beginning that not only being on the PEX and being on these special projects that the expiration would be extended until the projects had been completed, and that it was also promotional.
Have you thought of applying for the job 1840?
Yes, I have. I have applied for quite a few 1840s, and I have been told that I do not qualify. I have applied for 1823s. I've applied for a number of positions within the 18 series. And I've been told that I do not qualify. I went to DHR and I spoke with the front office and I asked them, how do you get on the list to take the test for an 18 position? They told me all you need to do is apply. Once you apply, you will be notified of when the test takes place. I've never been notified of any test for an 18 series.
Have you had any counseling with your HR department with regard to how to seek promotional opportunities?
Yes, and I've been told that I do not qualify.
Okay, have you talked to Mr. Brown about how?
Stop this, Sandra.
Okay.
Sandra and Civil Service Commission. Ms. Jones actually has come in to visit our office recently and has shared that with us, and our staff is conducting an investigation.
Oh,
I'm being informed that she was
On an
disqualified.
investigation, on an investigation, oh, okay, on an inspection service?
Yes.
Any further questions?
That's it.
Commissioner Salson?
Ms. Jones, thank you for your very thorough presentation to us. It's obvious you're very detail-oriented and a can-do person. But I had a question about the nature of this claim, which is in the nature of EEO, and the complaint that was submitted was for age discrimination. And I'm wondering, I didn't see anything in the materials as to something that occurred that made you think there was age discrimination.
The only thing that I could possibly think of, I know that something was, I'm being discriminated against for some reason, for what I really don't know. All I know is that there have been a lot of people being hired that are younger than I am, and so that led me to believe that perhaps it was age discrimination.
Two questions actually for the department. It has to do with the accusation that there's an 1840 that's being groomed for a 9139. And I was concerned because as I was going through it, I was looking at, well, what is the merit system process here? Has there been any investigation by your office about how that process is working?
I'm sorry, can you repeat the question?
It has to do with Mr. Chan. Okay, and the fact that there is an issue that he is in 1840, I understand, he's being quote-unquote groomed, that was the accusation, to a 9139. And I just was, it piqued my curiosity in the sense that I'm concerned about the merit system process.
Can you tell me what page you're referring to?
I'm referring to the appeal, and it is on page 11, and again on page 22, and again, I believe on page, yes, again on page 25. Maybe I'm sorry, I know.
Commissioner, being the person she is, number the pages. So I'm going to ask you to go through and or ask Commissioner Preventi to state it was at the top of the page 11 or 12.
I'm sorry, because that is one of the things I do. I don't see things numbered. It starts with, I told Mr. Mayor if he wanted to know why the hours were included, and I paid for Mr. Mayor, I guess it is. It's relating to, but it's on the bottom of the page. It's starting like they're grooming and training Mr. Chan to be a 9139 transit supervisor, not the 1840 that he was hired for. Again, we've got another reference on the page. It says, so on top of all my other regular duties. Again, there's the same kind of reference. And then again, on another page where it starts off, we also discussed Ms. Kirschbaum's harassment. And again, there's this, the idea that there's a person who's on the payroll as an 1840, possibly being groomed for 9139. My question is related to the merit system. The Commission does have broad authority. I understand that this is an EEO, this is a complaint that is related to discrimination. But when I see things that I think that we need to take a look at as far as the merit system, I will ask about those, and it's being presented here as an issue, and that I was wondering if you had looked into it. That's number one question. Number two, I want to confirm, was Ms. Jones on and 10.104-18 requisition for her PEX appointment?
Okay, so as to, thank you for your questions, Commissioner. As to the first question regarding Mr. Chan possibly being groomed for a management position, we have not looked into that as that claim is outside the scope of EO jurisdiction. the appellant did not claim that there's any sort of connection regarding Mr. Chan's training opportunities connected to age, race, gender, or any other protected category. Therefore, we have not looked into that.
Do you connect with your HR division when you see something like this? It's outside, I understand, your scope.
Right, that's something we can absolutely bring to the HR department's attention at SMTA, but we cannot as of today.
It sounds like that is, with regard to the merit system, is something that I would be concerned about. The next is the confirmation that she is on the 10.104-18 requisition, or was on as for 1840.
Yes.
That's 9 in the back there.
Yes. Yes, she was.
Okay, was she adequately provided information about the parameters of an exempt position? Did you happen to take a look at that? Because it seems to me there's a root here, there's an issue here.
Right.
And it sounds as though she was told that it was going to be extended over and over again. As we know, we have certain limitations. And was she provided with the actual documentation or the parameters of her appointment for at the time of appointment?
I believe she was. Let me take a quick look. 1 minute. Sure.
Good afternoon. My name is Rebecca Sherman. I'm EEO Programs Manager at DHR. I don't have information responsive to your specific question, but I can speak to, generally speaking, when an employee moves from an underlying PCS position, they take leave for a temporary exempt appointment. They have to request leave for that, and they also sign a document explaining that the position, the exempt appointment that they are going to move into for the next X amount of time is limited in time. The charter's category is identified on that, and that is easy for us to check in payroll to make sure to see if that exists. Yes, so we can definitely follow up about that and communicate with the appellant and provide her with a copy of that as well if she'd like to have that.
I think it's important because those parameters are very important when accepting a 3-year limited appointment. And oftentimes, if it's been expressed otherwise, or if she didn't sign her paperwork, or if there wasn't paperwork provided, that would be something that would need to be addressed as far as your HR department is concerned.
Absolutely, we will follow up on that.
All right, thank you.
Just the 1840, the leave request was continuous, there was no end date. And I can provide you with a copy.
Find a job, you click on the link. When you look at the job in, for example, classification 1840, it says at the top, click here to be notified of when there's any posted openings. So that's what we tell people to do. I hope that anybody at our front desk did not give incorrect information, but that is what we're going to do.
And that would be good for perhaps
to go from employees of the MTA about discrimination, about poor treatment. We heard a lot about that at the hearings. And so she deployed Dolores Blanding, who many of you know is a long-time HR manager of the city, to go into the MTA and act as an ombudsperson. Over the last 2 months, she's been meeting with employees and pursuing information about not just discrimination, but how employees feel about working there and how they're treated. And she will be making recommendations to both the mayor and the director of transportation.
Thank you, Ms. Callahan, for that update.